President Jacob Zuma and the Umkhonto weSizwe Party have called for 6 Constitutional Court justices to recuse themselves from hearing the IEC's matter involving the former president. Now, the court is expected to hear the Electoral Commission's application on Friday. The IEC is seeking clarity from the court on its implementation of Section 47 of the Constitution. Now, this is the same law that the IEC used last year to disqualify Zuma from the 29 May ballot. But that decision was overturned by the Electoral Court, prompting the Commission's appeal to the Apex Court. According to Zuma, the Chief Justice Raymond Zondo, alongside judges Madlanga, Majid, Mhlanta, Theron and Chikri, are all tainted by bias and are therefore not fit to hear the matter involving him and his new party, the MK. So for more on this, we are joined by Mbekezeli Benjamin from Judges Matter. Mbekezeli, a pleasure to have you on the program this afternoon. Firstly, tell us, what are the legal grounds behind Jacob Zuma's request for the recusal of these Concord judges in the case? And also, how does Zuma argue this prior involvement affecting the impartiality?
Good afternoon, Josh, and good afternoon to the viewers. Thank you. So in his court papers, former President Zuma and the MK party make 2 sort of contradictory statements. Firstly, they say that they want the judges to recuse themselves. But before doing so, they explain, that is the MK party and Mr. Zuma, they explain that yes, they understand what happened in 2021, that the Constitutional Court sent President Zuma for contempt to a prison sentence, and the aftermath that happened. And it is water under the bridge. It is no longer an issue that President Zuma feels any sort of resentment for, any sort of ill will towards the court or anyone who was involved in those proceedings. It is water under the bridge. That is what they say in the papers, and they also add, let bygones be bygones. But later on in their court papers, they say that these 6 justices must recuse themselves because they were involved in the previous case. Now, that is contradictory because at one point you say this is not an issue for you, but at a later point you say that this is an issue for you, and it is such a serious issue that you want the judges to recuse themselves. And that, for me, I think, is where there is a little bit of trouble, because when you want a judge to recuse themselves, you argue that the judge is either completely biased, so you have to put up facts to show that the judge is biased, or there's a conflict of interest between his role as a judicial officer and maybe another relevant circumstance, or you say that the judge, there is a reasonable apprehension of bias, and the reasonable, you say, someone who is a third-party observer, who has no interest in this case, when they were to view these facts, they would come to a conclusion that this might raise an apprehension of bias. And unfortunately, because of the contradictory statements that Mr. Zuma makes in the court papers, I don't think that it is viable for him to argue that there is a reasonable apprehension of bias. There certainly there are no facts to say that these judges are either conflicted or they are completely biased against him.
Mbekezeli, with this context in mind, how do you see the balance between upholding constitutional provision, but also ensuring fair treatment, especially in the electoral process, but also especially concerning Jacob Zuma's eligibility as a candidate?
Look, the key question that is before the Constitutional Court is the meaning of Section 47(1) of the Constitution. So Section 47(1) subsection E, that is. That is what this case is about, and how to properly interpret that section. It is not a rehearing of the contempt application, or whether or not the sentence that was handed down in 2021 is correct or not. That is a completely irrelevant issue. It is not before the court in this case. So what the court is looking at is the meaning of the Constitution and the interpretation of the Constitution. And the point that you raise again is, how does that balance against the right to participate and stand for office, because that is a right guaranteed by Section 19 of the Constitution. And the court might be at a position where they contrast and compare that right versus the prohibition in terms of Section 47. Because what the prohibition is saying is that if you've been convicted of a serious crime where you were sentenced to 12 months or more without the option of a fine, then you are disqualified from being a member of parliament. And the reasoning is very clear that people who committed serious crimes, they shouldn't now come back and want to stand for office where they will be making the law. So that is the rationale behind it. And that is what the Constitutional Court will be looking at. And so it will not necessarily be looking at the particular facts and circumstances of Mr. Zuma's case, but they'll be looking at all other cases. How does this disqualification from a person who's been convicted of a crime, how does it apply and how does it balance against the right to stand for office in terms of Section 19?
So as you've mentioned, the IEC is seeking clarity on Section 47(1)(e) of the Constitution. Can you explain its significance for democratic governance, but also the integrity of the electoral process as well?
So Section 47(1)(e) and maybe if Section 47(1) generally, it sets out a list of the grounds that you could be disqualified from holding office. One of those grounds is if you are a official employed by the government. The other ground is if you have been declared insolvent, so you are unable to handle your financial affairs and you are under financial administration, then that is also a disqualifier for you. The other grounds include mental capacity, and then there's this ground that says if you've been convicted of a crime, you were sentenced to 12 months imprisonment without the option of a fine. That is also a disqualifier, and it lasts for 5 years after your completion of your sentence. And the real reason for all of these grounds is to protect public office. Is to protect the holders of the elected office in parliament, to make sure that there are people of integrity, that there are people who can handle their affairs, people who comply with the law and follow the law. So those disqualifiers are there to do that. And so the issue now has been what is now the effect of the sentence? And as you know, initially the Electoral Commission said the sentence means that you are disqualified. The Electoral Court said the sentence, no, if you've been granted a remission, there's a difference in sentence. And so now the Constitutional Court must clarify what that sentence means and what does remission or we could say your sentence has been cut a bit. What does that mean for your standing for public office?
So very interesting is that Zuma's team is also arguing that this matter isn't urgent and may fall under the National Assembly's jurisdiction. How urgent do you perceive resolving this kind of issue, but also given its impact on the electoral process?
Well, look, it is extremely urgent because the elections obviously are about 3 weeks away now. But the other issue is if the Electoral Commission was to sort of not seek clarity from the Constitutional Court and let the elections run, what it would mean is that people who were disqualified in terms of the Constitution would now be elected into office. And that would contradict the constitutional provision itself. And so that is why it's quite urgent that the Electoral Commission gets that clarity, because if, for example, someone stands for office and we as voters vote for that person, and then later it turns out that the person was never supposed to stand, what would happen to those votes? What would happen to our votes once we've made that choice? So there are multiple people involved here and multiple rights affected. And so that is why it's important that the commission goes to the Constitutional Court and get that clarity before that election, which is, again, 3 weeks away.
Mbekezeli, it would be amiss of me not to also probe you around our breaking news story, and that, of course, relates to the breaking news about the ANC's decision to postpone its DC against former President Jacob Zuma until after the elections due to it cites security concerns. Now, given the precedent that was set by the July unrest, does this move come as any particular surprise to you?
Well, unfortunately, I'm very bad at analyzing politics, so I don't have a response for that. And I wouldn't want to venture a guess on security-related issues that falls outside of my area of expertise. So I'm really sorry.
Simply taking my chances there. But as we wrap up, what could be the implications for the judiciary's integrity if Zuma's recusal request is accepted or even rejected?
Well, look, it wouldn't do anything for the integrity of the judiciary. In fact, I think it would be positive for the integrity of the judiciary because what Mr. Zuma is putting forward is legal arguments to say that the judges of the Constitutional Court must recuse themselves. And of course, those judges will hear the legal arguments from both Mr. Zuma and the MK party and from the Electoral Commission and other parties. The effect of it, if it is granted, the 6 justices would now not sit in the case. Now, that means that the minimum that is required to sit in a case in the Constitutional Court would not be met. So the quorum requirement, because the Constitutional Court requires a minimum of 8 justices to sit in any one case. And so if 6 recuse themselves, then only 5 will be left, and that means the case cannot proceed. What it would effectively mean is that the Constitutional Court cannot now deal with the case, and the finding of the Electoral Court will stand. The Electoral Court the Constitutional Court will no longer entertain the merits of the case, and the election will go ahead. That would be a positive thing for the judiciary, I think, because it would mean that our judges have integrity and they understand and comply with the law such that they were willing to stand out of the case as is required by the law, and the case will then be dismissed. That is not a bad thing at all. Even if the Constitutional Court finds that there are no grounds for recusal, they will set it out clearly in their reasons. Again, that would be good for our judiciary, because in any of those circumstances, they will be in full compliance of the law and the Constitution.
Mbekezeli, let me thank you for your time as we conclude our discussion with Mbekezeli Benjamin, who's a legal expert from Judges Matter. It also becomes quite evident that the legal battle surrounding former President Jacob Zuma's eligibility does raise profound questions about law, democracy and governance in South Africa.